We're talking to Mark Deem, partner at Cooley, whose practice involves commercial litigation, international arbitration, and tech, media, and communications. Hi, Mark. Thanks for talking to us.
Pleasure.
Mark, just to start off with, what's the biggest issue going on in your current practice at the moment? What are you identifying as, a tech partner's main issues that you're focusing on?
Without doubt, as a litigator, one of the biggest areas of my practice at the moment is issues concerning cybersecurity and awareness of data and the vulnerabilities that data can create for our clients and for the wider industry.
Is big data and all the EU regulations and that an issue for you at the moment?
It is. It's undoubtedly something that is getting our clients very concerned and very anxious, but actually we're working with them to make sure they've got processes in place which enable them to be compliant. We're very much living in a world at the moment which is focusing a lot on information. Within the past 21, 22 months, more data has been created than has ever existed in the world to this date. And so therefore, there is a huge explosion going on at the moment. And so clients are very interested in ways that they can not only extract and harness growth of their businesses through the use of that data, but they also have the countervailing threat that that data creates for their business. And they really have to address that threat and work out how it could represent a vulnerability for them. And so we're working on both sides of the coin with our clients, really.
Do you think that there are currently really solid ways of protecting clients' data from breaches?
There are ways in which you can minimise the risk, but unfortunately it's one of those areas where you can't ever eliminate the risk. There's the analogy I like to use of two people who are in the jungle who suddenly come across a tiger as they come into a clearing. And they look at each other and they wonder what they should do next. And one person then bends down, takes the backpack off, and then puts on the running shoes. And the other person turns to him and says, "Well, what are you doing?" And he says, "I'm getting ready to run." And he said, "But there's a tiger, you're not going to outrun the tiger." He says, "All I need to do is I need to outrun you." And it's very much like that in the world of data and data protection in many ways, because for some businesses, they just want to make sure that they are not more vulnerable than their competitors and others in the marketplace. So yes, you can minimise the risk. You're never going to eliminate the risk, but it becomes a relative form of security, if you like. You want to make sure that you're stronger and more secure than your competitors, because that's where the real vulnerabilities lie.
And obviously there are huge advantages to be had from the vast amounts of data that are now available online and so on. Do you find that your clients experiencing difficulty, or are they still in the process of finding that right balance between being able to take advantage of all the data that is available and remaining compliant in terms of privacy issues and things like that?
It becomes an ever greater challenge for our clients. They are capturing more data than they ever have done before. They are wanting to try to harness that data and use it in ever more innovative ways to try to really drive some growth for their business and to try to find new products and new solutions in the marketplace. But that has the real threat as well, because they will be capturing more personal data along the way. If you take something like big data, for example, it is possible, it's conceivable that you might be sort of fusing two data sets which don't contain personal data in themselves, but through the process of aggregating and fusing those data sets, you are creating personal data. Now, when consent is something that enables you to deal with personal data, it's very difficult to get consent when you've not actually created or collated that personal data from the get-go. That personal data has arisen out of a process you're performing. It is very difficult then to get consent. So there are challenges that are being presented, but that's part of the fun of the job, to try to work out where those challenges are and what we can do to help our clients.
How do you see those challenges developing? Do you think the balance is close to being struck there?
Not quite. I mean, the real challenge for us as lawyers is that we are having to deal with very old-fashioned laws and very old laws to deal with very new problems. And that's part of the fun and part of the challenge for us as lawyers. I don't think I'd ever want to get into a situation where the law is trying to overtake technology and trying to anticipate problems, because as soon as that happens, we end up with a problem. Because as lawyers, we're not great technologists. If we were great technologists, we'd be out there creating and coming up with innovative technology solutions. What we have to do, however, is we have to be flexible and have to work out how we can take those old laws, those laws that have been around for some time, and give them new life, and how they can help us deal with the new problems that are arising for our clients.
And obviously, security and data protection is obviously also incredibly important for law firms themselves. We've seen the rather significant and controversial consequences of what can happen when a law firm's information is leaked with the so-called Panama Papers. What do you think are the implications of that, just from a legal perspective? Is that instructional in any way for other firms and lawyers elsewhere?
It's a good wake-up call for the legal industry, actually, to be brutally honest. We have a number of clients who have a lot of very sensitive information, and for some law firms, their clients will have better security than they themselves have. So in circumstances where you are an individual or a company who is trying to access or hack into that data, you're going to go for the weakest link. And if the weakest link in the supply chain happens to be the law firm, that is obviously where you'll target your efforts. And given that law firms tend to be receivers of some very crucially sensitive information in some instances, if they are the weak link, then they have a vulnerability themselves as a business. And so the whole Panama Papers issue, I think, has been a real wake-up call for some law firms to say, well, actually, we need to get smart and box clever here. We need to make sure that our security is as good, if not better, than our clients.
And apart from data, obviously, you've been heavily involved in other technology matters from a legal perspective for several years. Other than data, what do you think is the big issue after that? What are you most interested in as a technological advancement and its legal implications sort of going forward?
What particularly fascinates me at the moment is convergence. What we're seeing is a lot of old, what were formerly distinct technologies all converging in one space. 65% of the country now walking around with a smartphone. If you think of the number of technologies that are all converging into that one sort of device that we're all carrying around with us, it's quite outstanding. We have anything from sort of cameras through to video capability, through to phone recording, to communications, to data transfer. It's all coming into one place. And what that means is that for players in the technology, they have to work out what their proposition is for the market. Are they content providers? Are they hardware providers? Are they a mixture of both? And that is the real sort of dynamic shift that we're seeing at the moment as this convergence carries on.